did indicate that you should have the opportunity of putting in submissions in reply.
Yes.
You haven't put any in. I just wanted to confirm that that is your position.
Well,
in other words, that you've said whatever you wanted to say in your original submissions.
My Lord, it was slightly confusing because initially the direction was submissions in reply, and we understood that to mean submissions in reply, and then we sought clarification, and the answer that came back from the registry was that it was simply in relation to the Article 18 point. And so we limited, I mean, I have the correspondence here, but we limited our written submissions to the Article 18 point, knowing that we were going to have this oral hearing, and then perhaps my Lord would direct us as to whether or not there was any particular issue that needed
that's
us to address. And
that's not my understanding at all, and I'd like to see that correspondence. Do you have it there?
Yes. My Lord, we don't have copies of this, so maybe I can perhaps just say out loud what I'm referring to and then hand up copies to the bench if appropriate. But the email that was received from the registry is dated the 13th of December from Aisha bin Calvin. Dear Sirs, at the end of the hearing, directions were given for written submissions from the claimant and written submissions from the defendant, with any further submissions and perhaps oral submissions to be later considered. Upon consideration of the proceedings with the assistance of the written submissions, the judge proposes A. Claimant should have an opportunity if he wishes to file written submissions in reply, and there should be an oral hearing which he can raise with the parties matters which appear to him to require attention and receive submissions thereon. This is not to be an occasion for the parties to make further submissions beyond those in response to matters raised by the judge. Oral hearing may be by video conference, necessary for counsel to re-familiarise themselves with the case of the hearing, so that all matters can be dealt with. Judge is amenable to whichever course the party may agree upon. Although we consider submissions face-to-face to be preferable, please advise within the next 10 days. Parties are kindly request to provide a complete copy of the employment contracts. And that's the first direction. Then in response, there were conversations between the parties as to whether or not there would be an oral hearing, and if so, when. December 14. Refer to your email dated 13th of December. Parties have conferred as to appropriate directions and agreed the following: an oral hearing to be scheduled as mutually available in February, oral hearing to be held face to face, claimant to file and serve written submissions to reply by no later than 10 days prior to the date on which the oral hearing is scheduled. Joint available dates are 21st to 25th of February. Please find attached a complete copy of the employment contract. Then receive an email back December the 17th, and report saying the registry will confirm the hearing date early next week. And then in response, received an email back January 19th from the court. Dear Sirs, please note that the hearing has been listed to be held for half a day, Sunday 21st of February. The judge has asked that I inform you as follows. If it becomes relevant, the judge believes that this will be the first decision to consider the penalty provision in Article 18 of the law. Defendant has submitted that there is a discretion in its application. The claimant has not gone into its application into the various possible amounts owing. He would like to have the assistance of counsel by research identifying all available travaux préparatoire and identifying any likely legislation in other jurisdictions and decisions. He gives prior notice of this so that counsel can undertake the research prior to the hearing now appointed, and asks that the claimant include his results in the submissions. In reply, the defendant provide its result in supplementary submission filed contemporaneously with submissions in reply. From that, my Lord, we understood that the issue that my Lord wanted assistance on in reply was the Article 18 point, and that was our understanding.
I don't understand how you could possibly have read it that way. Prior to that email, you were to file your submissions in reply 10 days before the hearing. That said, include the Article 18 submissions in them.
Yes, my Lord. I can see how it can be read in that manner.
Well, I can't see how it can be read in any other way.
In which case, my Lord, in response to your question, we have more or less dealt with the defendant's points in our written submissions. As you'll see, they're quite comprehensive. However, we would seek the indulgence of the court that if it becomes necessary today, that we are allowed an opportunity to respond to anything that may arise following the oral submissions that you hear this morning.
What I am prepared to countenance, because for a variety of circumstances, the judgment in this case has been delayed much longer than anyone would like. To go back, what I'm prepared to countenance is giving you a brief opportunity today when we've finished our other business, if there's anything particularly important you want to say by way of reply.
I'm grateful, my Lord. Thank you.
All right. Okay, well now I'll start with some rather mechanical matters where I really need confirmation or clarification or some fairly mechanical assistance. The first thing is this, that you'll recall that there were the minutes of the 27th of December and the 7th of January of meetings between the two gentlemen.
Yes.
I don't have the bundle reference at hand, but those minutes refer to an attachment A. It's my understanding that the bundle or the exhibit does not include an attachment A. I wanted to confirm that, and if there is an attachment A, I want to know what it is.
That's correct. I can provide the reference to you for your note today, if that helps. It's bundle F1, and I think we have copies of the bundles here actually, Natasha. I don't know if you want to assist in handing those up, please.
It's probably unnecessary if you're agreed about the presence or absence.
Just for your notes then, the 27th of December 2012 minutes of meetings is at tab 42 of F1.
Yep.
And it's page 362. The 7th of January meeting minutes are at F1, tab 43, page 365, and in response to your question, subject to what my learned friend says, there was no attachment.
Okay. Now, just let me, going back to on what I said, just let me take a quick look at those tabs.
Tab 42 and 43.
Yep. Right, that leads on to the next question. If you look at tab 44, please. It's a piece of paper headed payments made by something towards the incentive of Mr. Adil.
Yes.
I wonder whether, because it was the next tab that was meant to be the attachment, it did not fit with being the attachment. So that is not the attachment?
No, I can assist with that. That was created by Mr. Adil's previous lawyers and presented as part of their disclosure in some way to assist in explaining what went behind it.
So really it is not evidentiary at all on anything that I have to decide. I really totally ignore it, don't I?
Indeed, yes.
Okay, that's good. That's got that out of the way.
Your Lordship, can I just clarify one issue? You have two documents. One is minutes of the meeting, which is at tab 42, and minutes of the meeting at tab 43, I think, two sets of minutes. And I think it's accepted that they are an amalgamation of the minutes of two sets of meeting, December and January.
That's right. I think one lot is what Mr. Chakravarti prepared, and the other lot is what Mr. Adil prepared. Is that right?
I'm not sure that's exactly right, but I think it's accepted that both documents record accurately what was discussed and or agreed at these meetings.
My Lord, the first set, as I understood and do understand, is the minutes of the meeting held on the 27th of December. The second set relates to the minutes of the second meeting on the 7th of January, and the chronology was that the Frontline produced these minutes, and then Mr. Asif Adil commented on them. So that's what I think Mr. Dar means when he says it's an amalgamation.
They both say that they are minutes of both meetings, so I don't think what you said can be entirely right.
That was my understanding, but in terms of the amalgamation, I think it's that they include comments made by both the defendant and the claimant. Is that correct, Mr. Dawes?
Yes, I think that's absolutely right.
Yeah.
And the only reason I raise it, Your Lordship, is you might think that page 369 and the section headed in summary will assist Your Lordship in determining what amounts, if any, remain owed or not. And I'm happy to make submissions on that.
I don't understand what you mean. Are you saying that they can assist me or that they can't?
They will assist you.
All right. No, that's fine. Yes, I understand that. Thank you.
And my Lord, just for your reference as well, the claimant deals with these minutes in his witness statement, and if I can just say, those paragraphs relating to these minutes are paragraphs 154 to 162 of the claimant's witness statement.
Yes. My recollection, and his only recollection, is that he says he got Mr. Chakravarti's minutes, he expanded them with,
and then
he
sent
thought
them
they
back.
were good enough and sent them back, and that's the second lot.
And he didn't hear anything back from Mr.
Right.
Chakravarti. Yes.
Exactly. Okay, that's got that one. Now, this is one for you. Your submissions in paragraph 228, in a connection which at the moment escapes me, say that Mr. Adil returned to work on the 18th of September. This was in 2013. He cleared his office on the 30th of June. He says, another version is that he cleared it earlier. And then he, plainly enough from the correspondence, he wasn't at work for a while. But you make that submission. I couldn't find the source for that. Can you help me? What is the source for saying that he returned to work on the 18th of September? Source in the evidence.
Let me, you bear with me, I will.
Indeed.
Please. check that point. I may have got it from the transcripts. I'm thinking.
Would your assistant be able to do some work to find out while we carry on with those?
Yes, of course, yes. And I'll find the reference for that.
Can you take that on notice, please? Can we come back to it a little later in the morning?
Yes, of course.
Now, the next thing, and this is a general query to both of you, or rather confirmation. Clause 29 of the contract says that it's governed by English law. No one has made any reference to that. People have relied on the DIFC employment law. I'm not suggesting for a moment that it doesn't apply because of that clause. I just want to make sure that you have both had regard to clause 29 and nobody wants to say anything about it.
Shall I start?
Please.
I'm just considering, and I have a copy of the law in the application of civil and commercial laws under the DIFC. The Lordship's aware of that. I'll have that copy in a moment. It seems to me that if you work with the water provision, as it's called, at Article 8, that where the law in question relates, or the matter in question relates to a regulatory matter, then the regulatory law of the DIFC applies. And as I understand it, and I may be wrong, but employment relationships are governed by the employment law, which is regulatory.
You need not go into detail. It will be enough for me if it is common ground that that clause does not affect the way each of you is arguing your case so far as it is based on DIFC law.
It doesn't affect the way we're arguing the case.
My Lord, the unfortunate stance that we have to take is that when we took over the case, it had been prepared by previous solicitors and we took over in April. Now, understandably, English law is more preferable to us because it allows us more protection, if I can say it in those terms, and there are clearly other legislation that we can rely on in terms of pursuing Mr. Asif Adil's claim. However, previously, as I understand, it had been accepted that the DIFC employment law was applicable. And in those circumstances, it was difficult then to depart from that.
Well, you don't depart from that then.
Yes.
All right. Well, so then I'll proceed on the basis that no one says that because of clause 29 there's some variation or some special approach that I should take. I just follow both your submissions so far as they involve DIFC law.
Yes. Can I just add one caveat to that, which is this, that insofar as there is DIFC law covering a particular aspect of the case, but no flesh on the bone, so to speak, I would invite your Lordship to defer to some of the English authorities that we have referred to in order to guide and or instruct, if necessary, on the application of those DIFC.
I think there's no doubt that that's an available course.
And insofar as there is a principle that isn't governed or codified in DIFC law, again I would invite your Lordship to consider applying English common law.
Well, that probably results from the cascading requirements of law which I apply in any event.
Indeed. And in particular I refer to the references that I've made to what is effectively reliance by a party on a breach that they were unaware of at the time that it occurred, insofar as it becomes necessary in this case, and some of the good faith cases that I refer to.
Yes, the Boston deep sea fishing case.
Indeed.
Yes. All right, thank you. Well, now we get to something a little more substantive. There's the debate about without prejudice material. Mr. Dar objected to parts of Mr. Adil's witness statement dealing with the meeting in Maputo towards the end of July. Essentially, and this is my summary, he says that that was the beginning of a negotiation process, and what was said at that meeting is within the without prejudice privilege protection.
Yes.
I think I have that sufficiently accurately as a broad summary.
Yes.
However, there was then cross-examination of Mr. Chatterverdi on that meeting. I take this as an instance because there were quite a number of other occasions when there was cross-examination by both sides in an area to which objection had been taken without protest. What I have in particular mind to try and focus is transcript day 2. Do you have the transcripts there?
Yes, we do.
Perhaps we can share.
Yes, share please. Day 2, page 245 will be a good way of focusing us, because I want to ask you about the principle of the thing.
Yes.
In fact, starting at 244, wait till you've got that page so you can see what I'm talking about. I think maybe if you start at 242, because I think in context this was that meeting at the end of July to which objection was taken. It's the meeting at the Hotel Plana. Now if you read on 242 and onwards, you see that Ms. Ahmed is asking what they discussed. At the bottom of 244 she specifically put, as part of the discussion, Mr. Chatterverdi said this, that or the other, and Mr. Adil said this, that or the other, and it goes on down to, well, it keeps on going for the next few pages. All this was without any objection from Mr. Dar. So I asked myself, what is the status of that evidence? Is that evidence before me despite the objection? Prima facie, to me it is.
Just give me a moment. I just want to read one particular paragraph on 245, which is between the two whole punches.
Let me know when you're finished reading.
Yes.
I'll just say another thing.
I've finished.
Right. I use this as a point of principle. I'm not too sure that much of the rest of similar cross-examination within the without prejudice area is significant. This might be. This is why I'm using it. So I'd like your submissions on whether that material is before me or not. That is assuming that I upheld the without prejudice objection. That of course must be the starting point. If I don't uphold the objection, then it must be.
Your Lordship, if you uphold without prejudice objection on the basis that any discussions with a view to settlement are covered by the blanket protection, then it must follow, notwithstanding the absence of the objection taken during trial, that that blanket protection remains in place.
Why must it? Because the function of counsel is to object when an objection is appropriate. An objection can be taken to A, B and C, but not to D for whatever forensic purpose counsel may have.
Your Lordship will recall that the indication that I believe you gave was that you would consider the material first and then take a view, certainly in relation to the documentary evidence and in relation to the paragraphs within Mr. Adil's statement, which are in essence oral testimony, that you would consider those first and then take a view later on whether they were subject to anything without
As to the objection to those specific materials. It was a specific objection.
Yes.
There was no objection to this material. That's the problem that I have, and that's why my prima facie view is that this material is before me. Now, for all I know,
think that's
there was
probably
some...
right. We don't take a strong objection to this particular part of the testimony, and that's probably why there was no objection taken at this point.
Okay, well, I raised it because for all I know there might have been some deal between you and Miss Arnia that this would follow the opinion. I would find it unusual if there was such a deal, as you didn't seem to be able to agree on the time of day. That was the trouble.
Your Lordship, if I think it's right to say that no objection was taken because at the time, I don't need to give an explanation as to why no objection was taken, but there is no objection taken to this material being relied on. Can I just make a general point at this stage?
Certainly.
Which is that discussions that are relating to settlement, even if they're not protected by without prejudice, need not inform you necessarily as to what the original deal was between parties. They're not determinative of that issue. That there are obviously wide strands of evidence that we need to consider.
Well, that's always so. Of course, any piece of evidence must be considered together with everything else. And I must bear in mind that what might have been said in negotiations towards a settlement was not necessarily correct or was motivated by something else.
Yes.
And all that I entirely understand.
Yes, of course.
What's any bit of evidence is not necessarily gospel.
And I say that we don't have objection to this segment of information or
All right.
record.
All right. Well, thank you. It seems to me that principle would apply to other similar material, though, as I have said, I'm not currently conscious of anything that is particularly important in a similar category.
Yes. And Your Lordship, insofar as there was objection taken to the inclusion of the minutes of the meeting of the 20th of December 2012 stroke the 7th of January, because there was some discussion about that. No, just to be clear, there's no objection to that material.
Yeah. No.
It really does essentially relate to the minutes of the 3rd of October.
That's right.
And the 7th of January 2014.
Yes. Yeah. Oh, the 3rd of October minutes are important one way or the other, so it's, I can understand a focus on them. Right, thank you. That assists. Probably not much for you to say, Ms. Ahmed.
No, even if I wasn't, I'll be in your court in any event, so...
Okay. Thank you. That clarifies that one for me. Now, so the next one is for you. Could you turn up the employment contract, please, and indeed give me a reference to it?
I think it's F110, isn't it? F110. Yes, F110.
Okay. Now, this is particularly provoked by your submission that any oral termination on the 30th of June was not effective because there wasn't writing.
Yes, that's correct. So
And I
paragraph
put that-
24
Yeah,
of
I
the
put that
employment
fairly in.
contract, yes.
Okay. Now, would you look then at clause 24? It occurs to me that when you read it with any degree of care, it allows for first termination by the employee giving the employer 3 months written notice. That's the first two lines, and that's irrelevant to us, well, save for the November resignation. Secondly, by the employer giving 6 months written notice to the employee, and that does say written.
Yes.
Or thirdly, by paying an amount equal to base salary in lieu of notice, which then seems to relate to what is said under A, the right to terminate without notice and to pay a sum in lieu of the notice entitlement. Or fourthly, of course, there could be termination without notice for cause.
Yes.
So there seem to be 4 things there.
Yes.
Now, it does occur to me that what happened on the 30th of June might be regarded as falling within the third of those. That is, it didn't need written notice. I wanted to get your response to that.
Yes, well, as you've rightly identified, there's 4 various sort of permutations of paragraph 24 of the employment contract dealing with the third permutation. The problem there is that if there was an oral termination, then the employer need not give written notice in the event that he pays an amount equal to his base salary in lieu of notice. Now, that didn't happen. And because it didn't happen, we say, in those circumstances, a written notice should have been given for the oral termination to be effective.
So you say that an oral notice, unless accompanied by payment, was ineffective.
Yes.
Why is it not right to say that oral notice to be given whereupon there is an obligation to pay?
But the defendant didn't accept that obligation. What the defendant's case was that there was no obligation to pay.
No, but there might be an obligation even if the defendant didn't accept it.
Yes. Well, in law there's an obligation, but
Indeed, I'm sorry to interrupt, indeed, that's what Mr. Adil was saying. He was saying, you are obliged to pay me.
yes. Now, whilst, clause 24, we say outlines the obligation to pay, but also makes it a positive action to pay. So the defendant had to pay in order to avail itself of not giving written notice. the employer had to pay an amount equal to your base salary.
Well, that really comes back to what I put to you as might have been your submission, namely that it was ineffective unless it was accompanied by payment.
Yes, indeed.
Okay. Now, I understand that, and that's something which I may or may not have to grapple with, depending what I decide on other things.
Yes.
I'll come back to see what Mr. Dale wants to say about that in just a minute. But as a flow-on from that, let's assume that, well, let's ask what is the sum which must be paid, because subclause A goes on to say, being a sum equivalent to your gross basic salary. In the present case, what do you say that is? Is that any more than the $600,000 payable at $50,000 a month? I.e., does it include what you say is the equity grant money? That's the real meat of it, isn't it?
Well, we would say yes, because that forms part of the claimant's wage.
No, we're not talking about that. We are talking about the words gross basic salary.
By paying you an amount equal to your base salary, and you've noticed that period company reserves the following rights, determine income and values, including pay your sum in UBS, equivalent to your gross basic salary. And well, the question then is, what amounts to gross basic salary?
Yes.
And we would say that gross basic salary is not only the cash remuneration, the $50,000, but also the equity grant, because that was part of his gross basic salary.
Well, what do those words mean?
The equity grant element, or equity contribution, however you want to describe it, we would say was contractual. There's no discretion involved in the payment of that equity grant, and so therefore we would say it's not as if it's an allowance or a bonus or anything of that nature. It's a prescribed payment to be made every quarter of the year, which would form part and therefore form part of the basic salary.
Well, I wonder if that really answers the question. I am aware of the evidence of their discussions, and I'll have to decide just what part that plays in things, which include, according to Mr. Adil, in saying that I want something equivalent to my previous 1.1 million.
Yes.
And
They
that
came
it
to this
flowed
arrangement.
from that things were structured in terms of 600,000 plus 500,000. I'll have to decide what the effect of all that is.
Yes.
But in fact, it was structured in a way of cash and equity grant, whatever equity grant means. Consider the situation where an employee is to be paid a salary plus, at the end of each year, on any view, a distribution of a grant of shares. Quite plain that it is no more than a grant of shares in his employing company. It may be a grant which depends on profitability. That's a fairly common sort of thing.
Mm-hmm.
What would the gross basic salary be there?
Well, again, my lord, it would depend upon whether or not you can read into a particular provision like that a discretion to pay because it's conditional, or whether or not an argument could be made as to the effect of it being contractual, and also obviously look at how the payment was made historically, and therefore would that lead to a conclusion that payment was contractual of equity shares in that scenario?
You're saying that the criterion is whether it's discretionary or whether it's obligatory.
Yes.
So your answer to my question about the shares, assuming it's obligatory,
Yes.
even though the number of shares may vary according to profitability, is that would be part of gross basic salary.
Yes. Applying that to this scenario.
Right. But how in that situation would you say an amount equivalent to, you have to value the shares, what do you do?
In the scenario that you provided, you would probably have to value the shares. But in our case, we don't need to do that because there are clear payments that...
I know, but I'm testing the principle.
Yes.
Yeah. All right, well, I understand your position, I think. Mr. Dale, I might then hear what you want to say on those two questions.
On the first question, Your Lordship, perfectly permissible construction that you advance, so I have no quandary with that. In relation to the second question, I don't say it applies there, obviously you know what our position is regarding the termination, but it's for serious misconduct, and therefore
Yes.
there is no issue as to payment in lieu or payment of any kind. In relation to the question of whether or not gross basic wage or gross basic salary includes the equity grant, the term gross basic salary is defined in the contract.
Oh, is it?
Yes,
Is that?
it's 3A of page 7 of the contract.
Sorry. Aha. Now this is the trick where the page is missing.
Sorry, I'll just ask.
Sorry.
Do you have a complete copy of the
Employment.
employment contract, which includes page 7?
It was emailed to the registry.
I understand. It was actually emailed to the registry.
I know it was sent to the registry and I got it, but I don't have it with me.
Well, Lord, you can have my copy. Is it just page 7 you're missing, or is it 7 and another?
It's 7 and 9. I'm not in the bundle.
Right. Well, I will give you my copy of the entire contract. I'd ask you to ignore any.
Look, no, I can get another copy. If you can, could you just read out for me and Miss Amy what the definition is?
Yes. It's clause 3, your salary, the position, and then sub clause 3A, basic salary effective 1st September 2011. You will receive a gross basic salary of USD 600,000, USD dollars 600,000 only per annum, equivalent to United Arab Emirates AED, which will be paid in 12 equal monthly installments.
All right.
And then,
Well, you say that cuts the ground out from under this army.
indeed.
Okay, I understand that.
And just on the wider point of principle, in terms of an equity grant, it would be unusual for the parties to have intended for a payment of an equity grant during a notice period in circumstances where it's obvious that the employee was leaving. What would be the benefit of it for an employee that's leaving? We would say that the purpose of the equity grant is to reward contribution, but also to provide an incentive or loyalty to the employee to stay on. And in the circumstances of this case, that is perhaps what the purpose of the equity grant was.
Well, I don't know that it was, given the evidence of their discussions beforehand, but they ended up structuring it in the way the contract says, and maybe, and I stress the word maybe, nothing is certain until I've decided.
Indeed.
Maybe Mr. Adil will suffer because of it.
I just want to make one other observation. I don't know whether your lordship has picked up on clause 32 of the contract, which is at page 20.
Yes, I'm quite aware of that.
The entire agreement was effectively.
Okay, thank you. That was that point that I wanted to raise and to ask you about. Now, next is really confirmation should these matters become significant, my understanding is that as at the 30th of June 2013, the salary, that's what we've just been talking about as gross basic salary, was up to date.
Yes.
First of all, is that right? Is that agreed?
Yes,
Right.
yes.
My understanding is that as at 30th of June 2013, the equity grant, assuming that it is to be looked at in the way that Mr Adil says, that is that he was entitled to money which he then put into one of their joint venture companies. So, in other words, assuming against Mr Dar's submissions for the present purposes, was not up to date. It was paid only till the 1st of April. In other words, there's a quarter still outstanding. Is that right?
That's not agreed. We don't say that's incorrect.
Okay. Well, in that case, I need to know what the evidence is, because it helps me decide.
Indeed.
So I might go to you first on that, Mr. Dar. Can you help me on what the evidence is that shows that it was up to date? That's your position?
Yes.
Okay.
In fact, we would say that based on just as a headline at this stage, that the amounts that were paid to the claimant, and much will depend on how you categorise them, that in fact there has been that the payment in respect of the equity grant is fulfilled right up until what would have been the expiry of the claimant's notice period had he been given it on the 30th of June.
Is this your submission that there was overpayment?
Indeed. And I can take your lordship through that.
Yes.
Now, with a slight modification.
Well, no, I understand what the submission is. What's the modification?
Well, it's really in terms of the figure, because there are a couple of variables depending on what of the evidence your lordship prefers. So perhaps the easiest way to do this is to just take you briefly through the evidence of the payments and err on the side of Mr Adil in terms of how he categorises them.
Okay.
As I think you would prefer that I do at this stage. Your lordship will note that the equity grant can be paid, or the equity contribution, if I can call it in that sort of neutral fashion. So a payment for shares by PDEL and by FDPEL, both what we loosely term either associated companies or part of the group company of FDPL. But there's no dispute that ultimately Mr. Suresh Chaturvedi was the beneficial owner of the entity that owned FDPL and PDEL. And you'll note in the employment contract that shares or an equity grant can be provided in the group company. So we know that PDEL made a contribution towards equity, we say, of a total of $639,821 US. Of that amount,
How do we know that? What was that figure again?
639,821.
You'll have to tell me where you get that figure from.
Indeed, Lordship. The starting point is to look at the employment contract. Paragraph 92 of the claimant's witness statement. If I can just take you to that first. What that deals with is the budget for Frontier, which he says is 1.2 million. What he says there as well is that each party was to contribute 300,000.
I'm not interested in what each party should have contributed at this point. I'm interested in the evidence of what they did contribute. But even more than that, I'm not particularly interested for present purposes in what PDEL contributed. It's a question of what was paid to or for Mr Adil
Well, this was
by
paid.
way of this equity grant.
Well, we say
On the assumption, contrary to your case, that he got cashed. I don't. You must have some difficulty when your case is he wasn't entitled to it anyway. But
well, Your Lordship, I don't think he's saying he's entitled to cash. I think he's entitled to an equity contribution on his version of events. In other words, that either PDEL or FDPL would make contributions towards the equity of a venture, and that's precisely what did happen for his benefit and the benefit of PDEL. There's nothing in the contract that prevents PDEL from making that equity contribution on his behalf.
Will you tell me where you get this figure from?
Yes. So, Your Lordship, if you first turn to, if you go to bundle F1 and to page 101, you'll see that there are a series of payments made by PDEL. So it's at, I think our tabs are misaligned, but it should be at tab 16 or 17 of yours. And you'll see on the front cover there's a sheet that was put together by the claimant's previous solicitors. Now, can I ask you for a moment just to ignore page 101, which is a payment by PDL to the claimant of $200,000 and turn to page 102. Pages 102 to 108 show payments totaling $319,973. Those payments were made between the 17th of February and the 23rd of July 2012, and these were referred to during the course of evidence at our trial. So the important figure there is $319,973 and the Indian rupee amount, 17,054,070 Indian rupees. Those were payments made by PDEL to machine suppliers, and the position is that that was the equity, or part of the equity contribution that was made by PDEL towards the shares in the business. They also then, you recall, made a payment of $200,000, and that's page 101. You can see PDEL makes a transfer to the claimant's personal account of $200,000 on the 11th of June 2012. And finally, Your Lordship, you will note that pursuant to the terms of the consultancy agreement between PDEL and the claimant, which incidentally was signed on the 30th of May 2012, around the time that these payments were made, that the claimant was to be paid $300,000. Now, can I just ask you to turn very briefly to your tab 22, I think, and it's page 171A of the fund. It may be your tab 24, 23 or 24. It's page 171A.
Yeah.
And you'll see there that's a consultancy agreement. And clause 6, which is next to the second whole punch, provides total consideration to the claimant of USD 300,000. And of course, you'll have considered, or will consider, our evidence in our closing submissions regarding what these payments were intended for. We say it's simply a mechanism to make that equity contribution on behalf of the claimant. But the sum there, you'll see that it says the claimant's already been paid $84,000 as of the date of this agreement, 30th of May. He then received a further $200,000 on the 11th of June, making a total of $284,000. If you added that figure to the payment, we say, which is the real value of the payments made to machinery suppliers because of currency devaluations. You get 339,821 plus 284,000, which gives you 623,821. And your lordship.
Well, just to stop for a second, Mr. Adil said in his evidence that the consultancy agreement was incorrect in that he had not already been paid $84,000.
Yes.
It was put to him that he got it in cash,
Yes.
he'd been given it in cash, and you said no, he hadn't.
Correct.
And there was absolutely no evidence at all, I think, from your side that he had.
Well, apart from
Of payment in cash.
apart from the fact that he's signed the consultancy agreement to claim to, which we say is powerful evidence that he had received that sum.
The way these gentlemen conducted their business, I wouldn't believe anything they wrote.
Well,
Not prima facie.
that's one way of approaching the case, but certainly you won't discount, your lordship, what we say
Right.
about the effect of
Well,
this.
that might be a problem with the 84,000. Mr. Adil also said that the 200,000 had nothing to do with his equity grant.
And that it was part of the consultancy agreement.
Yes.
And the
So would I have to, in order to accept your submission, I'd really have to deal with those two statements by him, wouldn't I?
But what I, in my submission, puts the matter, makes the matter much clearer is what Mr. Adil says in an email, which he sends to the parties. Which he sends to Sharp and Co. And that's an incredibly important email.
Is this the yes as to $300,000 email?
Yes.
Well, that I think is that is good as to $300,000.
Well, what it does show is that the claimant accepts that he received an equity contribution of 300,000 towards Frontera by PDL, and that the other 300,000 they paid towards machinery suppliers by way of a contribution of equity in kind is theirs. So he's almost accepting that he's had 300,000 of an equity contribution. And we say,
Well, let's assume that only gives you 300,000.
I'm happy with that.
Gives you 639,000.
I'm happy with that. So if we accept that he's had a payment there, sorry, I have to go around the long way to get there, but that he's had an equity grant in 2012 of 300,000 so far. Can I then invite you to look at the minutes of the meeting of December/January, which were at tab 42, because this then sticks in neatly the next piece of the puzzle.
So then F1 tab 42, yeah.
You'll see that at page 369, so F1 369, and this is not disputed, this is accepted in the claimant's witness statement, well certainly the first part is accurately reflecting the discussion. F1 369. And it's point 3 at the top of the page. Mr. Asif Adil's compensation agreement with Mr. Chaturvedi, which is 600,000 his salary, and then USD 500,000 to be given as an annual equity contribution by Mr. Chaturvedi on behalf of Mr. Adil in various businesses agreed between them. Now, what follows is helpful in shedding light on what was paid and what is owed for 2012. In summary, a total of USD 800,000 has been contributed by Mr. Chaturvedi, of which 400,000 is for his own and 400,000 is on behalf of Mr. Adil. Now, pausing there for a moment, we know that roughly 600,000 was paid in terms of the transactions that I identified. Your Lordship will recall, and I'll take you to this in a moment, that a further 200,000 was transferred to Mr. Adil's account on the 25th of December 2012. You recall the email that said on an ad hoc basis against you.
Yeah, that's part of the 778,000 odd that was in dispute.
Well, what we say is that, yes, I think we're saying the same thing, that effectively that was another part of the equity contribution, which topped up from 300,000 to 400,000 would have been paid so far in 2012.
Your case at trial was that it wasn't. Your case at trial was that it wasn't.
But working on the assumption that what the claimant is advancing in terms of the principles that he's advancing, that underscore this case, that those are correct. It tallies with this, which is that as of the 25th of December 2012, he's had 400,000 by way of equity grant. And then, Your Lordship, if you turn over if you look at point 2, a total of USD 1.2 million is to be contributed by Mr. Chaturvedi in 2013, of which USD 600,000 is for his own account and 600,000 on behalf of Mr. Adil. This includes the 100,000 shortfall in contribution against compensation in 2012. So he's due another payment, and we know that there's another payment that's made on the 27th of January 2013 by cheque to Mr. Adil in the sum of 734,000 dirhams for $200,000, of which, and all of this is spent by Mr. Adil, but of which 100,000 represents an equity contribution on behalf of, let's just call it the FDPL group of companies, and the other 100,000 is for Mr. Adil. And that then, we would say, brings closure to payments that he's entitled to for 2012. And Your Lordship, if I can just ask you to turn back to 366. And this is important. To the right of the first hole punch. Both parties then went on to discuss the fund requirements of the current business. Based on attachment A, which we don't have, it was agreed between both parties that Mr. Suresh Chaturvedi has given USD, that should say 800,000 to date. Because by now we're past the 25th of December, of course. He would be given an additional 200,000 for 2013, for which USD 100,000 would be given on behalf of Mr. Adil. See attachment A for details. This subscription would bring closure to Mr. Adil's 2012 compensation. So he's had his 2012 compensation. And implicitly, it means that either he wasn't entitled to anything in 2011, or the clock started ticking from the beginning of 2012. That seems to have been agreed between the parties. So that then takes me to 2013. So we covered compensation for 2012 by payments in December, 25th of December 2012, and then another one on the 27th of January by cheque, half for Mr. Adil and half for the NDPL group companies. So we now have to pay another 500,000 in 2013. He gets a payment of 266,666, and then 111,111, giving us 377,111. Now, if you worked on the assumption that the payment in December of 200,000 and the payment on January 27th, 2014, none of that was used for the benefit of the FDPL group companies. As the claimant says himself, this was all mine. Then in fact, he's had an additional 200,000 on top of that 377,000, which brings a sum total of 577,111. He's had his contribution. If he doesn't pay back a penny, he's been overpaid in equity grant for the entire year by 77,000. That's what we say the maths is. Now, if, on the other hand, was lawfully dismissed on the 30th of June, then he owes us money, and there's a set-off provision under the contract. That's all I'll say at this stage.
Thank you. Well, Sonia, I take it you disagree with all that?
I do indeed disagree with all of that. If I can just take a step back and in response to your very first question, as to what payments were made and whether or not they go towards the equity contribution. His first year employment would have been from the 1st of September 2011 to the 31st of August 2012. During that time, it's the claimant's case that he was entitled to be paid by way of contribution $666,667 US. Between that period, 3 payments were made to him. The $200,000 paid on the 25th of December 2012, and we say that goes towards his first year. There were then 2 payments made on the 27th of January 2013. First one was $266,667, and the second one was $200,000, which gives a total of $466,667. And we say that was the balance of his first year equity contribution. There is then the second year of equity contribution to be paid, running from the 1st of September 2013. That would have gone up to the 31st of August 2014. But of course he resigned on his case in November 2013. His case was that the payments were due every quarter, so the balance payable was the $333,333 to be paid in 3 quarters. First quarter payment was made on the 30th of April 2013. You'll recall there was a payment made of $101,111.
111,000, I think it was.
Yes, that's right. $111,111 US.
Which in fact is not a quarter's payment, but it seems to have been treated as such.
Yes. And then the second quarter and the third quarter was due. So there was a payment due in July of again $111,111, and then a payment due of the same sum in September. So we say that was outstanding during the currency of his employment. Then turning to a number of points made by my learned friend, the references to PDL making payments, you'll recall PDL was the vehicle by which the equity contribution payments were to be made. The defendant says that PDL formed part of a group structure, although there's no documents, legal documents before you telling us what, in fact, legally the group structure is. And so we say PDL is a completely different entity to FDPL. In relation to the payments made by PDEL, they were made in 2 tranches for equipment. The first tranche was February payments, and the second tranche was June-July payments. Just in relation to the February payments, I think my learned friend said that the payments that were made totaled $319,973. Just going back to those documents then, F1 tab 16, page 102, ignoring for a second the $200,000 payment that was made in June, but dealing with the February payments, we see one payment 17th of February being made to SSP, and that's for $12,500. Over the page, 17th of Feb payment being made to Global Pet Industries, $36,735 US. Third payment to Optimum Machineries, $63,555. Fourth payment to Ashtami Polychem, $8,197. That amount comes up to $120,987, not $319,973. Unless my own friend took into account another figure that I haven't
page 106.
factored in.
72,000, then 21, and then
I'm looking at trouble by a few $100 or even a few $1,000 here or there on this.
Yes,
The
so
figures
sorry.
are in a bit of disarray. Let's just work out without worrying about a small amount.
Sorry, I'm just dealing with the February payments. The June payments were entirely separate. So the February payments, I understand you to be saying, were 319.
No. The entire payment was up until 23rd of July, 319972.
Fine. The 200,000, my lord, you correctly identified, was paid arising out of the consultancy agreement. We say the consultancy agreement has nothing to do with any sort of equity contribution payment. This was an agreement whereby the sums were due to be paid for services rendered by the claimant over a period of 10 years, and therefore those sums should be treated separately.
What does this amount to? What do you say 320,000, let's use a round figure, paid by PDEL to various suppliers was? Do you say that was PDEL's own contribution, or that it was a payment in fulfilment of the equity grant obligation?
We say it was PDEL's own contribution under the shareholders' agreement that was supposed to be entered into, and we say it was nothing to do with the payment.
Nothing to do. So, in other words, we just try and get to the essence of it. So far as Mr. Dar relies on the 320,000, you say no, that wasn't equity grant money at all.
No.
So far as he relies on the 200,000, you say no, that wasn't equity grant money at all.
Yes, it was under the consultancy agreement.
Well,
Yes.
Okay, I can see that issue. Now, what more do you want to say?
That I will leave it there. So we say, well, finally, we say the outstanding amount to be paid whilst the claimant was employed was the July payment and the September payment of 222,233.
Okay, thank you. Anything in reply to that, Mr. Mayor?
Yeah, I just want to make one short point, which is when you look at the repayment by the claimant of, which you'll see the same series.
23,600.
Correct, not 19,000 as the claimant would have you believe was the overpayment to suppliers. There's no evidence of any overpayment to suppliers. They were paid exactly what was contracted for in INR.
He doesn't say that it was no payment for suppliers.
He does. He says it in the witness statement.
No, he doesn't. Let's move on.
So,
one thing that does occur to me, Mr. Dar, do you recall Exhibit 31? I think it was an exhibit to Mr. Adil's witness statement in reply. He said that was a document that was produced by Mr. Mahareshi at the 3rd of October meeting. There was no objection to it. It purports to be Frontline's statement of what was due and had been paid to Mr. Adil by way of equity grant.
I'm not sure that was actually put to Mr. Maheshwari. Can I just remind myself?
Please do. It was not put to Mr. Maheshwari. It was not mentioned by anyone. It was simply left there as a piece of uncontested evidence given by Mr. Adil.
Yes.
It seems to me that it presents a difficulty for you. I'm not exactly sure where it is in the bundle at the moment.
It's in the witness statements folder behind tab E in the reply witness statements.
I don't think I need it at the moment, depending on what Mr. Dar wants to say about it once he's found it.
It's tab, bundle E, tab 27, and at the end of Mr. Adil's reply witness statement. It's this one here.
I don't know that.
he had represented the payments as incentives in the meeting on the 3rd of October when he handed me EX31 document clearing closest payments totaling 667 incentives. So that's... And then let's go to the...
Well, Your Lordship, I don't have that attached to my documents at all. And I don't recall that being put in cross-examination either. Mr. Maheshwari or Mr. Chakraborty.
It wasn't.
It wasn't. you say?
It wasn't.
So, I mean,
It didn't have to be.
well,
Nor was there any cross-examination of Mr. Adil saying that that didn't happen.
Exactly,
I
which
don't
is
have
why I
that
was
Well,
document.
what am I meant to do about
No,
that?
nothing. I'm just making the point that the document doesn't appear to have been provided.
Well, the witness statement refers to it. You didn't have it, then prima facie that was because you didn't read the witness statement.
I did read the witness statement, but there was another, I believe. Yes, Your Lordship, but that would only be problematic if you took the view that the minutes of the meeting of the 3rd of October and indeed documents that were prepared in contemplation of that meeting for the purposes of achieving settlement were not protected by the without prejudice privilege.
No, it was not. That was not objected to.
Well, I haven't seen it.
Well,
The difficulty, I can't say for certain it hasn't been served, but this is the bundle that we got from the claimants.
have you seen it now? Ms. Ahmed provided you with it. Can I just go back for a moment, Mr. Dale? I'm sorry to interrupt your reading of it.
No, not at all.
My recollection, which I think is accurate on this, is that when the question of without prejudice, of how without prejudice privilege would be dealt with was being discussed, you said that you had identified the paragraphs of Mr. Adil's first witness statement to which you took objection but had not had the opportunity to consider his witness statement in reply. The next day, or at least later, you said you had considered that witness statement and there was nothing in it to which you wished to object.
Well, I'll have to check the records.
Well,
but if that's your recollection, then
I'm pretty confident of that. By all means, satisfy yourself. But if that's so, I don't think you have much of a leg to stand on.
Well, Your Lordship, if this document is not given to us, it's difficult to appreciate and understand what exactly is being put. And this document doesn't appear to be given to us at all.
If the witness statement refers to it, then if you didn't have it, you should have asked for it.
Well, the
And
witness
I'm
statement,
not going to enter into what occurred within your office.
well, on the assumption that you have no qualms about allowing this to stand as evidence, Your Lordship, I make these observations.
Please, that's where we should be at, I think.
Firstly, even if you don't believe that these are covered by the without prejudice blanket, I make the same observations that I made before, which are that the fact that if this is done by the hand of Mr. Maheshwari, that the fact that he's recording periods and amounts due isn't a statement of fact. erring on the side of the claimant and saying, well, on the assumption that you're correct, these are what you'll be owed. And that is the only way that my submission you ought to give to this, given that this arises without prejudice negotiation. And more importantly, if we look at the document that is agreed by all parties, which is to say, the minutes of the meeting of the 7th of January 2013, amalgamated minutes, those clearly are in conflict with what is set out here, if indeed these are done by the hand of Mr. Maheshwari. Or alternatively, Mr. Maheshwari must have ignored deliberately for the purposes of reading some sort of settlement what was said and agreed between Mr. Chaturvedi and the claimant as at 7th of January 2013. And I say that's quite important when you're attaching weight to this document vis-a-vis the document that is contemporaneously produced on or around that time.
Yes, I understand that. Thank you. All right. Well, that was the matter that I wanted to raise about what was outstanding, and I think I originally began as at the 30th of June, and that was, of course, on the assumption that termination of 30th of June made that a relevant matter, and there's an awful lot of what I'm raising is on various assumptions adverse to one or the other party, obviously. Now, can I then confirm this? My understanding is that after the 30th of June 2013, Frontline did not pay Mr. Adil anything. Is that right?
As I understand it, they gave him a week's salary.
No, I think. Well,
Sorry, they offered a week's salary.
They offered a week's salary. Said they were going to pay a week's salary. He protested and said I should have more.
Correct.
But in fact, nothing was paid. That is my understanding, and I would just like to have it confirmed to make sure I'm not going on barring up the wrong tree.
That's correct.
And including, and here I'm looking at the 3rd of October minutes for purpose of the question, which said you will be paid this, that and the other. Nothing of that was paid.
No.
Okay, that's good. Thank you. All right. Now, next one for you, Simon. Just let me find what I need to refer to. To understand what I'm going to ask about involves quantum in my next couple of queries, and I need to understand just what quantum is about. Whether I get to quantum is another matter, but I need to understand it. There are really two steps in my question, Samir. If you go to your closing submissions, if you have them handy, please.
Yes.
Paragraph 232.
Yes.
This might be described as extremely brief. He set out his claims in his witness statement. Now, the only bit that I could find in his witness statement was paragraph 315, which I think talked about two things, and
relative to the rest of the submissions, you could criticise that paragraph, but
Well,
I should have made it clear, the reply submissions deal with quantum, and that's it, the reply witness statement, it's the red folder.
Right. In that case, I must have not gotten on to that one.
I think it's probably me not making it clear. So it's Series E, tab 27, and attached, do you want to just take that out? Attached to that witness statement is a schedule of loss. Do you mind if my...
Yeah, please have that.
Yeah.
Thank you. I have not realised that this is what you were referring to.
Well, my apologies because I didn't make it clear in that paragraph. So. All
this is on the assumption of your, what might be called your primary case that you resigned in November.
Yes. There will be various permutations
there will be
that.
variations.
Yes.
So, but let us address it in terms of principle, because
yes.
I'd like to understand just what the heads are that you are claiming.
Yes.
One is unpaid salary.
Yes.
Salary, strictly so called, is 50,000 per month.
Yes.
Second is unpaid equity grant, and I use that term loosely.
We say it's according to the schedule, it's the notice period.
I'm sorry,
Yes.
you are right. I skipped that over. I beg your pardon. Notice period payment.
Yes, and that it's not 3 months, it's 6 months, isn't it? If we resign. Sorry, I just need to check that.
But it depends on whether you're relying on a resignation
Yes.
in November
Yes.
or...
Yes, exactly. I just need to check that with the contract at 10.
If it was resignation in November, then he'd be entitled to salary for the next 3 months.
Yes,
He'd
that's
get
correct.
Salary.
Yes.
If, however, there was a termination in June,
Yes.
if
Then
it was
it's 6
termination
months.
for cause, nothing.
Yes.
If it was termination on the alternative we were discussing a bit earlier,
Yes.
it would be his base salary,
Yes, that's correct.
whatever that may be.
Yes.
Okay, so that's that head.
Yes.
Right. Thirdly, the unpaid equity grant. On your case, it would be from the beginning of April
Yes.
2014.
Yes.
On Mr. Dahr's case, it would be zilch because he'd already got it.
Yes.
Depending again on just when the termination occurred.
Yes.
If the termination or if the end of the employment was in, by virtue of the resignation, then presumably there would be some more payable if it was entitled to things at all.
Yes, on the claimant's case, there would be equity or an equity grant payable between the date of the last payment in April and the resignation date, but not the notice period following the resignation, based on the same principle that he's only entitled to gross basic salary during the notice period and not an equity grant.
I need to look at the clause again, but
Yeah.
I understand what you say, that I'm not conscious at the moment that that's the way it works where there is a resignation by him. Anyway,
Yes,
that we
understood.
can work out if necessary.
Mm-hmm.
Now the next then, that's 3 of them. Fourthly, then there's the gratuity.
Yes.
And that's under the employment law.
Yes.
Fifthly, there's the payment in lieu of driver's charges.
Yes.
Sixthly, there's payment in lieu of out-of-pocket expenses.
Yep.
And seventhly, there's what has the potential to be the big ticket item of the penalty.
Yes.
So they're the heads of what we might loosely call compensation that you are claiming.
Yes.
Okay. Now I follow that. Now let's just look at them for a moment, please. Take the unpaid equity grant. In the schedule appendix 4 from his witness statement in reply, it's just taken at a proportion of $500,000 per year.
Yes.
I wonder if that is the right approach. Let me explain why. The equity grant on any view, assuming it was able to be satisfied by a payment of money, was a payment of money which then was to be, under the deal, had to be invested in a group company. Do you agree so far?
Yes.
Therefore, if he were given an amount of money representing some period, let us assume the period from the 1st of April to the 30th of June, that would have strings attached. You would have to invest it in a group company.
Yes.
I think it's fairly plain that the way things are, that wouldn't happen.
Yes.
Is the correct approach to his compensation for failure to pay that equity grant, let's assume that he was entitled to it and didn't get it for that 3 months, rather the value to him of what he would have got from investing it in a group company. That is his loss, the damages for the breach of the contract of failure to pay.
Yes, I see that.
And if that's right,
There's no evidence of that.
you're entirely with me.
Yes, no, I can see how you would adopt that approach. What I would say in response is that if a strict reading of the contract were to apply, then of course he would have to, during the currency of the contract, invest it back into a joint venture. At the point that the contract then is terminated, query, is he still obliged to make that payment that he would have been entitled to into a group venture?
I really can't see how you can split it. The entitlement was on terms.
Indeed. But if I suppose if you find his contract was terminated but without cause, then because the defendant has taken away his ability to invest back into a group venture, in those circumstances, I would it be payable?
Well, there is still the ability to do it. It's a practical matter. We can be sure it won't happen. But there's nothing stopping it. They have their side arrangement for co-investment in Frontier and any other things that were on the boil.
Yes. In
So
which case,
I wanted to raise this with you because it seemed to me that it was a way of looking at it which you might not have considered.
Yes.
Which I must say did have some legs to me.
Yes, I mean, another argument potentially could be that you have this shareholders agreement in the background, and under that agreement, Frontera are saying that they're entitled to a share subscription. In the event, would another approach be in the event that the contract is terminated and therefore the claimant doesn't get the benefit of clause 7, is that something that could be set off against the shareholders agreement? Now, I can see the problem with that.
My problem is I don't understand you. Say it again.
Well, there is this shareholders agreement, and pursuant to the shareholders agreement, the PDEL were entitled to a share subscription. Now, under the employment contract, PDL were making these equity grant payments. In the event that the employment contract was terminated, the claimant loses the benefit of clause 7. In those circumstances, could that be linked to the shareholders agreement, and could there be any sort of deduction set off in relation to that? But I think there's an inherent problem with that because there's nothing that provides for that to happen.
Okay, well, I still don't understand you, but I gather that you've thought better of it. Anyway, look, there's that problem. I don't know if there's any more to be said about. I'll just have to think about that.
Yes. Yes,
all right.
And I might get some inspiration in the next half an hour. So
okay,
we'll see.
You'd better be quick about it. Mr. Darby, you want to say anything about that point? I'm going to go on to a couple of other of these heads too. But
I made the observation that I recognise that the Lordship has raised a perfectly valid issue which goes to damages and the inherent problem that it creates for, or possibly creates for the claimant. But can I just make this observation? Which is that the reason that problem regarding damages, potential damages, arises is precisely because the defendant hasn't had its shares in a group company from which the claimant would have been granted equity, or should have been granted equity. So in other words,
I don't see that that's got anything to do with the problem.
Well, if the issue is how does he get damages for him not making an investment in a group company, there isn't a group company that we can refer to, because the company that was meant to be a group company and from which the claimant was to derive the value of an equity contribution has not become a group company.
Ah, yes, well, I remember that submission in your submission.
But my point is, we come back to that same point. It reoccurs in the context of damages.
Yeah,
and it is an important point.
Okay. Thank you. Anything else?
Yeah. Your Lordship, I just wanted to clarify the position in relation to what we say is the failure of the claimant to allow subscription and or transfer shares to the defendant. You have our submissions on that point in some detail, but just as a sort of closure, just as by way of closure to that point, it doesn't appear to be disputed now that PDE, or during trial, that PDEL paid what it was required to pay in order to subscribe for those shares.
On the contrary, I think it was disputed.
And it still is.
Well, it's well, let me put the submission another way. It's difficult to see how it can seriously be disputed, given the email that you have seen between Mr. Shah of Shah and Associates and the claimant, where the claimant concedes that if there was a sale of the shares in Frontera, then PDEL would be entitled to compensation to the tune of 300,000. The remainder of that 600,000 being what the claimant describes as his balance compensation.
And that's only one little drop in the ocean on this topic.
Well,
Mr. Adil's case, as one limb of his case, it's not the only thing he says about this transfer of shares. He didn't have to transfer until PDEL had paid its contribution, while the initial contribution may have been $300,000. Thereafter, the necessary contribution became much more, and PDEL did not pay the much more.
yes.
And that, as I understand his case, I have to say that I am not entirely sure what the evidence is about what the required contribution became.
Well, the
Although one
attachment-
can see things, one can see reference to it in the minutes we were looking at earlier, but it's all terribly confused.
Well, I would just make this point, that when a party initially subscribes to shares in a company, it's not based on what they will pay or may pay subject to a change in budget, which I think is accepted, did occur in 2014, where the claimant says the budget for the venture Frontier went from 1.2 million to almost double that amount. It would be quite remarkable, in my submission, in terms of general business practice for a share subscription price to be provided effectively, for it to then be paid, but for then somebody to move the goalpost and say, actually, you've got to make contributions further. The additional contributions, the requirement to make those additional contributions are set out in the shareholders' agreement, but that is only a requirement, a standard requirement that you would see in a shareholders' agreement, where the parties agree to make contributions from time to time in accordance with their shareholding. It isn't, or doesn't make any reference to the subscription. And your Lordship will see that the effective date for the shares to be transferred under the shareholders' agreement is defined, and it's the date that it says both parties sign the shareholders' agreement. Now, this shareholders' agreement was signed in June 2012 by the other party and not by PDEL. But the fact that they don't sign it doesn't prevent them from having subscribed and paid for shares. We say that this agreement merely regulates the rights as between shareholders. What it doesn't do, in my submission, is prevent there from being ownership of shares in Frontier by PDEL. For example, if a party pays the shares or subscribes to shares, the board of the company, or the chairman, CEO, can pass a resolution granting an unconditional right of ownership of those shares, and that's what we call an allotment. That hasn't occurred in this case either. And your Lordship will see from subsequent emails in October and November 2014 that the claimant was effectively saying, I will give you your share transfer certificates or complete the paperwork that's necessary for that, provided you make the additional payments. So in my submission, it was the claimant that attached these additional requirements that weren't justified on the original subscription date. And so
that seems to recognise that, as I said, it was not it was his case that he didn't have to transfer the shares until the additional contribution had been paid. I think we're getting a little distracted at this point.
Well,
shall we go back to the headship claim?
If that's what you wanted to do, your Lordship, I just wanted to make the point in case those submissions weren't clear in my closing submissions that you've received.
All right, thank you. Now there's...
Can I just give you a reference for a point that you made about the contribution costs and where those figures come from? At the back of the claimant's first witness statement, Series D, tab 26, at the back of that witness statement is an Appendix 2, which refers to frontera costs and partner contribution requirements.
Thank you very much. I certainly do not recall that. All right.
My Lord, before we continue, may I just step out of the room, which will be for 2 minutes, and
Yes,
visit
certainly.
the ladies, please? Thank you.
Yes.
Just before you do your lordship case, it's not a power. Appendix 2 is just an appendix of the claimant's witness statement, a document he generated himself well after the event. It's not a document that was submitted at any point to the defendants as part of an agreement.
All right. Well, I'll take.
So that's clear.
Have regard to that. What I might do is take a short adjournment. We can all have a little comfort if we wish to. Back in 5 minutes.
Yes, I'm grateful. Thank you.
All rise.